New York State Real Estate Exam Review. Let's get started. A commercial lease in Manhattan includes a clause for rent escalation based on the Consumer Price Index. The tenant disputes the calculation. Under New York lease contracts, how is this typically resolved? Is it A, through arbitration if specified? Or B, by the landlord's discretion? Could it be C, in small claims court? Or lastly, D, automatically in favor of the tenant? The correct answer is A. Here is why. Commercial leases often contain alternative dispute resolution provisions, including arbitration, for resolving calculation disputes. If the lease specifies arbitration, that is the typical resolution mechanism. Option A is correct. Option B is incorrect. Landlords do not have unilateral discretion. Option C is incorrect. Small claims court has jurisdictional limits and is not typical for commercial lease disputes. Option D is incorrect. There is no automatic presumption. Next question. The New York City Department of Buildings inspects a renovation project. What do they ensure? Is it A, compliance with building codes? Or B, property taxes paid? Could it be C, fair housing? Or lastly, D, license renewal? The correct answer is A. Here is why. The Department of Buildings enforces the NYC construction codes, zoning resolution, and other laws affecting building construction and safety. Option A is correct. Option B is incorrect. Property tax collection is handled by the Department of Finance. Option C is incorrect. Fair housing enforcement is through Human Rights Commission. Option D is incorrect. License renewal is through Department of State/Consumer Affairs. Next question. A commercial property in Queens generates $100,000 NOI. Similar properties sell at an 8% cap rate. What is the value? Is it A, $1,250,000? Or B, $800,000? Could it be C, $1 million? Or lastly, D, $12,500? The correct answer is A. Here is why. Value equals NOI divided by cap rate. $100,000 divided by 0.08 equals $1,250,000. Option A is correct. Option B, $800,000, would be 12.5% cap rate. Option C, $1 million, would be 10% cap rate. Option D, $12,500, incorrectly divides cap rate into NOI. Next question. In Manhattan, a real estate salesperson is working as a subagent for a seller's broker and finds a buyer through their own marketing efforts. The buyer asks if the salesperson represents them. According to New York agency law, what must the salesperson provide? Is it A, a verbal assurance of representation? Or B, the New York agency disclosure form? Could it be C, no disclosure unless requested in writing? Or lastly, D, a commission agreement? The correct answer is B. Here is why. Under New York's agency disclosure requirements, a licensee must provide the disclosure form at the first substantive contact with a prospective buyer or seller. Oral disclosure is insufficient. Option B is correct. Option A is incorrect. Oral disclosure does not satisfy the regulation. Option C is incorrect. Disclosure is mandatory regardless of written request. Option D is incorrect. Commission agreements are separate from agency disclosure. Next question. A real estate salesperson in Syracuse is renewing their license and realizes they have not completed the required 22.5 hours of continuing education, including the mandatory fair housing and agency topics. The salesperson submits the renewal application anyway, hoping to complete the courses later. According to New York real estate regulations, what is likely to happen? Is it A, the license will be renewed provisionally for 30 days? Or B, the renewal will be denied and the license will lapse? Could it be C, the salesperson can pay a fee to extend the deadline? Or lastly, D, the Department of State will automatically grant an extension? The correct answer is B. Here is why. New York law requires completion of continuing education prior to license renewal. Failure to complete the required hours renders the licensee ineligible for renewal, and the license expires. Option B is correct. Option A is incorrect. No provisional renewal is permitted for CE deficiencies. Option C is incorrect. No fee extension is available. Option D is incorrect. The department does not grant automatic extensions. Next question. A first-time homebuyer in Queens obtains a VA loan for a property purchase. The salesperson explains that this loan allows for no down payment. However, what fee might the buyer still have to pay under New York real estate finance? Is it A, origination fee? Or B, funding fee? Could it be C, appraisal fee? Or lastly, D, all of the above? The correct answer is B. Here is why. VA loans require a funding fee, which is a percentage of the loan amount paid to the VA to offset program costs. This fee may be financed into the loan. Option B is correct. Option A, origination fee, may be charged by lenders but is not unique to VA. Option C, appraisal fee, is a third-party cost, not specific to VA. Option D is incorrect because the question asks what fee the buyer might still have to pay in context of VA's unique requirements. That's it for today. How many did you score? Let me know in the comments. Please like and subscribe, and tell me what topic I should cover next. Bye.